Often when consulting with clients, they usually have two questions. The first being, what's the next step? The second being, how long is this really going to take? And there are some general outlined procedures and deadlines that parties have to follow in a standard dissolution of marriage proceeding. Initially, we as the attorneys, once you have selected and hired a counsel, your attorney may ask you to gather some general information. That information may be financial, it may be regarding your custody matters, in order for us to prepare an initial petition for dissolution of marriage. And your petition is going to outline the relief that you're able to seek in your proceeding. In addition, there'll be a standing order that will be entered when your petition is filed. That will require both you and your spouse to maintain the status quo during the dissolution of marriage proceedings. Neither of you are to run out and sell assets, transfer assets, change beneficiaries. It keeps things hopefully at a minimum and calm and able to move forward with the proceeding. Once your spouse is served with that petition, they have 20 days to answer that petition and file their own counter petition for dissolution of marriage. 30 days following the filing of the petition, both parties are supposed to attend a parenting seminar if there are children involved and custody matters involved. 45 days from the date that your spouse is served, both of you will be required to produce general financial information, including a financial affidavit outlining the budgets of the household bills and the list of assets and liabilities of the marriage. In addition, there will be certain documentation called mandatory disclosure that you'll each be required to produce. This will help the attorneys assess the assets and liabilities and the potential support issues in the case. Depending on how complex the case is, the attorneys may advise you to hire a forensic accountant to be involved in establishing values of assets and/or distribution of assets and liabilities. The next step would be attending mediation. Usually, mediation is where we're going to attempt to settle all issues in your divorce proceeding. Majority of the cases are resolved in mediation. If an agreement is reached in mediation, usually a full marital settlement agreement is drafted so that the parties may execute and solidify the terms of their meeting of the minds agreement. Finally, after the agreement is signed, a final judgment will be entered by the court. We will present your final agreement, the court will adopt it, and you will have the benefit of a final divorce decree to establish the divorce is complete. If the parties and their counsel can cooperate, the case may be completed within 3 to 6 months if the issues are not too complex. If the issues are more complex and/or the parties are unable to settle at mediation, likely you'll be scheduling the matter for trial, which could continue the case on for at least a year. If you have any questions or want to seek advice, please call the Byrd Law Firm for a consultation.